red there in the top left-hand corner, recording has started. Does everyone see that?
That recording started, so.
Okay.
Yep.
So at 13:10.
Thank you, Julie. So then I guess we've got the agenda. I know Julie put that together. There were 2 items on the agenda. I think since we're going to conduct this like we would any other bar session, probably makes a good idea. I know Jeff is probably the new person to the room, as is Martin. Just for everybody to quickly introduce themselves, and this helps for the record purposes. My name is Terry Harmon, counsel to the school board as it relates to labor discussions. Also here with Jeff Slanker from our law firm. Not sure Gary, Matt, or I know Martin, you know Jeff very well, but Jeff's also a lawyer at our firm that works on labor issues and helped with the MOU and some of the issues that we're going to be talking about today. So we're here, and then Julie, I'll let you, if you want to introduce yourself as well.
Yes, I'm Julie Sessa. I'm the Assistant Superintendent of Human Resources and serves in the capacity of the Chief Negotiator as well.
Yeah, just for the record, Martin Powell, counsel to Martin County Education Association for the purposes of the arbitration and working out this presidential release leave. And with me, I'll let Matt and Gary introduce themselves, although I think you guys know them.
Yep, and for the record, Matt Theobald, president of the Martin County Education Association.
And I'm Gary Simmons, Service Unit Director for the Treasure Coast Service Unit. That includes Martin County Education Association for the Florida Education Association.
Okay. And so I'll just kind of jump in and maybe kick it off. And obviously feel free to jump in. I know what we were looking to do during today's publicly noticed bargaining session was to address the issue of presidential leave, I guess we'll call it for short, for the upcoming school year. I know as it sits right now, there's a request from Mr. Theobald to have that request renewed. And we have the arbitration award, which is a separate issue that addressed some issues related to presidential leave. So what we wanted to try to accomplish during this session was really to focus narrowly. This is, again, school board's perspective on this, was to address leave for the upcoming school year. We still have our regular collective bargaining sessions that will need to get scheduled where we can address articles and contract language. But with it being July right now, school year getting ready to kick underway, is really to focus today's session on potentially reaching a tentative agreement through an MOU on implementation of the leave for this coming school year, at least so we can get that under our belts, and then we would address the language in the CBA through the normal collective bargaining process. So that was our thoughts for today. What we tried to do to make it a useful session is we worked separately, and I know you all have not seen anything yet, but we tried to put together a draft of a memorandum of understanding that we can share and go over. I know since we're virtual, it's a little different than handing over pieces of paper across the table. So I can share my screen, or I can, I can email it to you, or I can just drop it in the chat box, and we can go over it together if you just want to receive it and then maybe caucus, talk about it amongst yourselves. But what we tried to do, just to kind of lay a little foundation, is there were some things that were previously done. I know with prior MCEA president, there was some language from one of the arbitration awards. And then there was some of the desire of our side. We tried to memorialize that as simply as we possibly could in an MOU. So let me see if I go to the chat feature, I believe, yeah, I can add a file to it, and then you'll be able to take it. And if you want to take a break to review it, whatever works for you. So let me see real quick if I can save it.
Oh, you can share.
Yeah, but they may want to chat.
Understood. I'm not used to Teams a whole lot. We just switched to it July 1. Right, Gary?
I love Teams.
Well, so do I have to allow you to share just in case you want
Nope.
to? Oh,
I
okay.
can just drop it in the chat box and they'll be able
Okay.
to get a copy of the file. Let me
Okay.
see really quick. Make sure. Okay. Yep, I can do this. Add. See if you all are able to pull this out of the chat box in a second. Is it 7:10? Yep.
Oh, so far it's recorded like when we started recording and who's here, but I don't see it in there.
It says external users don't have permission to this file, but let me make sure I can. Well, then I can fix it. Okay.
I don't know what whiteboard is. You may have to send it to me. Shop it, Gary. I had lunch. You're going to be really happy about that.
She's struggling with Teams. Gary, you're muted, so you can't even say anything to her.
He was trying.
I see it on
It's
my
shown
end.
up
Terry.
on my box as well. I'm just seeing if it'll open up.
Great.
Yeah.
Yay.
It's open on my screen.
Oh, I got it too. Okay, great.
So does it
Okay,
make
does it
sense,
make sense?
Martin? Do you want to take a break or do you want to, how do you want to handle it now to be
I
able
don't
to
know.
look
Can
at
I-
it and talk?
Can I send them into a room?
Yeah, it might make sense to take a break so we can have a conversation. I don't know if it's a breakout room in the Teams or if we should just put it on mute and call each other. What is the best, easiest way to do that?
You probably should sign off, my guess, and then we'll stop recording. And then when you sign back into the meeting, the three of you, we'll just start recording again. And that way with the three of us can chat while you're off.
Okay. You guys, Matt, Gary, okay with that? Okay, let's do that. So we'll
Great.
sign off, come right back to the same link.
Okay.
See it. I see.
There it
Oh,
is.
there.
Yep.
Okay. At 2:09.
All right, so we've returned from our caucus here at 2:10, like Julie said. So we haven't had the chance to like really redline and go through things, but we have some kind of, we've gone through the whole thing and have some comments, questions to talk through, and hopefully that'll be fruitful is our thought, and then wherever we end up we can redline. So as far as the standard kind of whereas stuff, the entry paragraph, we don't have any concerns about the time period that we're talking about. We don't have any concerns about number one, which acknowledges that we President Theobald submitted the request. I don't have any concerns about number two or three, which outlines the terms, right? So I have a comment about number four, which is just in our conversations. We heard in the arbitration, that the board didn't even consider Matt an employee and that he was kind of, out to pasture. And so we wanted to at least float the idea in this conversation of a part-time arrangement rather than a full-time arrangement so that he can be considered an employee. I know this kind of solves some of those problems, but it also may present an opportunity to kind of respond to some of the issues that the board raised about, his classification. And so we wanted to kind of raise that because I think, the Education Association would be at least open to the idea. It would keep Matt closer to the classroom. It would keep him engaged. It would solve the evaluation part because he would have an evaluator. It would kind of solve some of these kind of around the edges issues. Now, it does create potentially some, as we kind of have to create like a part-time schedule for him and get those classes, half day or whatever that looks like. But we wanted to float that out there because I think it might address some of the concerns the board raised throughout the last year of this process, and it might also benefit MCEA. So I didn't know if that was something you guys wanted to discuss or were open to discussing, but it was something that we had thought about kind of in response to all of the concerns raised in the arbitration that we went through about the arrangement, and trying to kind of come up with something that, and again, met you, or at least in Mars, tried to meet you part of the way down the road into some of the board's concerns, into some of the non-fungible issues around this release time. So that was kind of the first thing, and I think it has an effect throughout. Obviously, if that was something that you'd be interested in, we could obviously just put in, into this like part or full-time release, and come up with an agreement on that. But I wanted to at least float that initially to see if that was something you thought there was an appetite for. It seems to solve a lot of problems, or some problems at least. But anyway, so that was kind of the first thing that I think. Did everyone leave? No, there you are. My view changed here, but yeah, so that was the first part on board, to see if I don't know if it's most for us to go through everything, or for us to talk about each item separately. What is your preference?
I can go through each one as we're going. I think this is effective. I can give you my 2 cents on the question. So as I'm just kind of thinking through it, you would envision if it was a part-time scenario where in the classroom for a portion of a work day, and then another portion of the work day would be presidential leave time.
Yeah, I think that's, yeah.
Okay.
That's I think the best example of that I think we have in the region is Indian River, who does like a 0.5 situation. I think their president teaches in the morning and not in the afternoon, I think is how they've arranged it. Gary will probably know better than me, but that's kind of the most. But yeah, anyways, yes, to answer your question.
I do have Indian River's language, probably from Gary in my book. I also see Santa Rosa has partial release as well, right?
Yep.
Gary?
Yep. Yep. And I'm familiar with that. I guess the thing I would say to that is, candidly, our approach to this session with the MOU that we put together was contemplating the way that the presidential leave has been done in the past and the way it's written, which was, if you sign up for that, it's for 1 year. So I don't know if the three of us at the table, without having, I mean, that's more of a bargaining issue for purposes of the contract language, because it doesn't contemplate part-time in the contract. I think that might be better served for a different session, or we would potentially have to have another executive session, because we did not contemplate that approach to this in advance of today. So I think that might require another session.
Okay. Well, let me.
But I know the concept. I'm very familiar with what you're saying concept-wise, having had some experience in that.
Yeah, I know it's something that happens elsewhere. I just we thought it might address some of the board's kind of like I said, non-fungible, kind of things we could get our hands around, some of the concerns that were raised at the board meeting and in the arbitration. So we'll kind of keep that out there perhaps as a potential idea to hold on to. I didn't remember the contract actually identifying it as a specific release. I know it said for a year, but we'd still be talking about that. I didn't remember it's talking about the specific full-time versus part-time versus anything. But I'll pull that up as well.
Mm-hmm.
All right. Any responses that I need?
Yeah. The other thing I want to add one thing to it, and this may help explain what you addressed initially, which is like, what's the classification? I think as we've looked at it from an FRS perspective, in order for you to continue to participate in FRS, there needs to be an assignment or a position. That's why we use the teacher on special assignment position. So with the evaluation language that we put in there, the who do you report to language, again, that was all trying to tie it back to what can we do internally here at the district that worked for purposes of FRS in the past and would still keep that classification appropriate. So that's the reason we went with that language, is it worked in the past and we didn't draw a red flag, as I understand it. Is that what was done with Miss Resaniti, that same position, and it passed muster? That's why we went with that. So that's just the quick background on why we chose to go with that language.
Yeah. No, I think that's right. I think that's how it's kind of works across across the state too, as far as making, they need a position, right? I think that makes sense.
Yes.
Okay. Anything I missed, Gary or Matt, that you wanted to address
Well,
there?
no, I just wanted to say, Terry, though, that should it come to, you bringing that back to the board, at least in my mind, where I'm coming from is that I thought that would be helpful. We're not looking at that as a I understand that changes the approach here and it would require some tweaks here, but overall we wanted to put that out there in an attempt to be helpful. We're not trying to complicate things or throw a curveball last minute. We just wanted to throw that out there in an attempt to be helpful. We're not trying to be duplicitous in any way, shape, or form. I just wanted that clear for the record. That's all.
Okay. I understand. No, I get it was an attempt to address concerns, is how I'm taking it from you. But is that something separate from today? Is that something, I mean, that I guess would, just looking at the language of the collective bargaining agreement, my guess is if there was going to be a proposal as to part-time structure, that might be something that would need to be proposed in that context. But I just can't answer that today for time purposes.
Yeah, take a look at it, because I think it leaves, I mean, my position on all of this, right?
Yep.
The contract is broad and then the MOU narrows it. I think the contract language is very broad. And so I think it gives us a lot of ability in an MOU to make this work for both parties. So do take a look at that, because I think
I will.
What I'm looking at here, it looks possible. But yeah, I mean, again, we just thought it would help. But
I'll bring it up.
Okay.
I will bring it up.
All right. Then I'm going to skip on to 5, which again, I think, as related to what we talked about, part of release time, that could be, that would probably end up being a proportionate expense. We would pay proportionately. And I think that's going to carry through. That would carry through based on, that's why I wanted to address that kind of at the top, is if that was something that we could come to, it would kind of carry through a lot of these things. So that's the main thing on that. Otherwise, I think that we acknowledge that the goal of this is that MCEA will kind of pre-reimburse the board for the costs associated with these benefits, but that Matt would remain eligible for them if it is something that we pay for, right? Both employee and employer contribution. The only nuance added today is that if the board was desirable or open to the part-time conversation, that would be one of our conversation points, would be proportionate splitting of some of these expenses.
It would have to change the whole thing. I mean, you're right. It would have to break it up based on what time in the classroom versus direct representation activities, or if it was just a set hour. That would be, that's what I've done before too.
Yeah, and I think that, so we could look at people that have done that. I don't think it's too complicated, but
one explanation too to provide you, I know you're still going through, but on number 6, on 6BI, the $1,500 language, just to explain that, as I understood what was done with Miss Resaniti, there was like a prepayment, and then the board would, the MCEA would prepay, and then the board would draw against that, and it was never an issue. It was always done correctly. There was never a point in time where the board was basically pre-funding. And so if it works that way, it's perfect. What we were just trying to do, anticipating if a question came up of, well, what happens if there was a shortage where MCEA prepaid, but then the cost of benefits and salary for whatever reason exceeded it. We were just trying to build in like I don't want to say a deposit, but basically like a buffer that at the end of the school year, we would just return.
What happened?
Make it to where we never exceeded. So that was was the reason for that.
I think we saw that because we did have a question about it. Obviously, I think you identified that because our thought is that paying the month in advance and the board invoicing it, right? So the board invoices what the salary expenses are going to be, and we pay it a month in advance, kind of establishes the need for a security deposit type of thing. And so I think that both of those are kind of, I don't think it's necessary to do both of them, is kind of was our thought, is if we're paying a month in advance, the board's the one actually doing the invoicing. So if there's an overpayment or underpayment, like I think the board would know what they're going to be paying. So my hope would be that would be the case. And like I said, I do think it worked out with Ms. Resinetti's. So, I mean, I guess our thought would be one or the other. And I think the prepayment of a month in advance is probably preferable because it gives a larger sum and more of a cushion than the $1,500, but that seems to be an extra. So that was our thought on that, because we did look at that and it seems a little redundant to have both of those needed.
It is. Now that you say that out loud, I agree. If you're prepaying a month in advance, if you're paying in January what's going to be done in February, and February's payroll and benefits roll out and it looks like it's going to be $500 more than what that was prepaid, I assume. I mean, we would just draw down. Yeah. So I hear what you're saying. So is it, Jeff, I think, wouldn't it just be the language we had previously about, if there's ever basically a deficit, that MCEA would fill that deficit within so many days?
Yeah, I mean, I think that and that was language we had worked through, and that might be something that, if there's some unexpected, I don't know what it would be or the likelihood of that happening, but some type of unexpected change in a benefit premium or something to that matter that for some reason it cannot be anticipated.
Typically, we would anticipate, like, say he added family coverage or something, which would definitely bump up, right?
That would still be a month in advance.
Yeah.
Right. So, and I think we would agree to, we'll talk about when we see the specific language, but I think we would agree to the concept, right? We don't want the board to be, we want MCEA to prepay all expenses. We don't want the board to pay anything out of pocket that they all already have money in the bank for. So we're in agreement with the concept. And so if we need to put something in there that says if there are unexpected expenses beyond what is invoiced, like submit another invoice and within X days we'll pay that too, right? Because I think the month gives us that time to do, I think, if I understand it. And I think it's unlikely, but we'd want to, a bunch of lawyers on the call. We want to prepare for all possibilities. Okay. Talk about that. The evaluation piece, again, I think that we talked a little bit as a part-time piece that he would have an evaluation if he was part-time. We have two questions about this evaluation, and one's kind of on the back of last year, right? Which is that was a conversation under Karen's Resinetti's too. And ultimately, just so you know, the evaluation never got finalized, right? So the idea that this is required is like, okay, maybe, but if it didn't actually happen, then how much a requirement is it actually? And so, there's a little bit of a question internally about how how that even works, right? Like, if he's full-time release, you're evaluating him on his representation of members or his bargaining against you. Like, I don't love that, right? I don't love the idea of submitting the president, who is supposed to be wearing a cap similar to the superintendent, being evaluated by somebody that the superintendent designates to it sits all wrong with me just from a union concept. So I'm not super excited about it. I think I would also kind of, if we can get past that kind of major hurdle, I think that we would have a concern about just letting the superintendent designate. We would probably want to have a mutual agreement, right? But in general, I mean, I'd like to hear a little bit more about why we feel like the union president should be evaluated by the management employer in their union president role. Like, I don't feel good about that at all.
No, and in brainstorming that out with you, I would also it would be a tricky situation to have a school district evaluate whether or not the MCEA president performed his duties or her duties as MCEA president in an appropriate way. That just would be, I'm not sure, a bridge that anybody wants to cross or deal with. And that's not the intent. I think our concern is if you're an employee of the district, you're placed in a position, there is an evaluation instrument that typically attaches to that. How would we, I mean, it's a good question, Martin, and I don't think anybody wants to sit down and say, well, you didn't do a great job at that arbitration. So it's not at all what the intent. And I think, so I think that's open for discussion. I just don't know how best to evaluate whether it would be that. I just don't know. I don't know what the right tool is. So we went with what worked with Karen, but to your point, if it wasn't actually completed, I just don't know how that would play out for purposes of policies and for purposes of the requirement to evaluate employees. So I think.
Yeah. I mean, I think,
Julie, I
don't, yeah.
Statutorily, the performance pay, we do negotiate that, and that's based on evaluation. So if they're not evaluated, then they wouldn't get performance pay, or how would we? I mean, right now, with the way we did salary this year, it'd be $100, so it's not a big deal. I mean, performance pay, because we put my money in years of service. So what's the experience, Gary, if you have any, from where they how do they evaluate others? I mean, Indian River is part-time. The one in Hernando I just read, printed it, actually gave it to Hernando, says they'll be evaluated by an administrator, but it doesn't say what tool. I was just trying to research that a little bit on evaluation, but if performance pay eventually is put back where there's more dollars associated with it, then how do we do that mechanism that's statutorily required when they're not evaluated?
I don't know if, Gary, if you have experience in anyone with a full-time release leader on this situation. I don't know that it's come across it as an issue ever, so I don't know how they've been working on it.
I can make some inquiries with respect to how it's done in Indian River. I don't know that answer off the top of my head, though.
Most of mine has been where it's a part-time release where a teacher still functions in the classroom. If I'm truly brainstorming without doing any research, I think the evaluation would just be, I mean, did you not violate board policy? Did you not violate the law? Did you, were you present at sessions? Did employees complain about representation? Like, I'm trying to think of something that wouldn't require us to delve into the business of the union, which is not our place.
Did they follow board policy?
To the point, even like the description of the president is managed by like what the membership wants the president to be by their governing documents, right? So even doing that, I think, is somewhat difficult. Let's do a look. I mean, I guess that means we'll have to come back, but we have to do some inquiries on that to figure it out. And I think, I mean, if we come up with something, I don't know what the non-classroom teacher observation tool is. I mean, I don't think any of us really do, but if we have to come up with something, I mean, I guess figure out how this is even done. If there's like pay associated with it, then we don't want to forego that necessarily. But we don't want to agree to, evaluate Matt's job at the bargaining table or whatever.
Understood.
And if so, I think it should probably just be the superintendent, right? Like the superintendent and Matt can be the ones on the same page there. That makes more sense to me. But let's Gary, can you help me in like making some inquiries on that as far as, and I'll do the same. I don't know. You don't have any other full-time release people though, but I'll try to find some too.
Yeah, I can definitely knock that out.
We'll look too. We'll try to see what we can find out on our end as well.
Yeah, I know Hernando. I looked at their teacher on special assignment. And they had like 3 or 4, and theirs was much more vanilla than the one we have currently from 2005.
Are they full-time in Hernando? Are they full-time?
Yes.
Okay.
And I don't know if Indian River even, if they're part-time, they're probably passing them through on that 0.5 as just an instructional, like team member, like 5th grade teacher or whatever they are, right? Then
Oh, I'm sorry.
I mean, thinking then what happens with the FRS and the benefits? If it's 0.5, then I guess the arrangement is then half of everything still gets paid by the FEA grant, assuming there is one, so that it makes it a whole.
Yeah, it would just be proportionate. I think that's how it's done. I mean, again, like we're not recreating the wheel here. This is what happens, right? So we just need to have that, maybe even have that conversation with them. But I think that's right. I don't think there's any concern with that. FRS allows all these things to happen. We just have to tell them.
So we'll put a pin in evaluations. I think we just got to figure that out.
Yeah. We don't have number 8, sick leave. I don't have any concern about that, assuming, of course, that the Matt wouldn't be then required to report that he's out sick using sick leave, right? He's not getting sick leave, so he doesn't have to do that, right? Is that a safe assumption?
You mean when he's not performing his duties as the union president? I mean, he's on leave to perform those functions, so I don't believe he would have to I mean, that would be reporting while you're on leave that you're going on leave.
Right. Well, I think that's how it was, right? Because I think Karen was receiving leave on hers, and so she was telling people like, "Hey, I'm sick today. I'm going to be in bed or whatever." And she was getting, Julie, you maybe correct me, but I think that's what was happening there. And this is cleaner than that. I think makes more sense to just say like, we're not issuing you extra leave days, and you're not telling us when you're on leave. You work that out with MCEA. That'd
be my thought. I would expect that
it's cleaner actually.
Yeah,
I think our expectation would be MCEA would reach out and say, we're not prepaying this whole month because Mr. Theobald absconded from his position, like that. There would be a discussion versus not that would ever happen, but like that to me would be the nightmare scenario, right? Is, hey, our union president disappeared. Here's what's going on. But it's a good question though. I mean, I don't think we would have to track the leave while you're on leave performing other duties. So that'd be my take. But is that Julie, payroll have any, would they want to comment on that? Or should we run that by them just to ask if there's,
I mean, we could run that by them just to ask, but like right now, I think he's been on leave. We don't have any idea that he's on leave.
If you're not earning, then there's no, I mean, that's the issue. You would just want to keep track of it if you were earning it, that you were also reporting it when you use it. So I agree.
Correct. Right. We don't want to windfall because he's earning leave and not having to tell you. It either needs to be both or neither. And I think neither makes more sense. So,
okay.
So confirm with us with payroll if there's any major issues with that. But I think we're on the same page.
Okay.
9, it's a pretty broad release, right? So I'm trying to figure out what this actually covers and what the intent of this is actually to cover. we definitely talked about the workers' comp issue, 100% on board with that. But as far as like what if he's non-renewed at the end of the school year, and does he have the ability to challenge that? What if he's retaliated against, or does he have the ability to file anything, or what if he slips and falls? That one of your ability? I mean, is he treated like a citizen, or is he treated like he has no rights to do anything for any circumstance under it, for anything, right? That's what it kind of reads to me like. And I don't know if that's the intention, or maybe it is.
I think if I were to say it in a one page paragraph, one full page indemnity language way, is if there was a loss attributed.
Uh-oh, did he freeze?
Me?
Yeah.
I'm frozen.
Not now, but you did look at the ceiling, so I'm just reminding you that.
I'm not looking at the ceiling. I'm not. I get accused of looking up. I'm gonna look down at y'all from up here. I think that the thought of the board would be that if there was a loss or a claim or a harm somehow connected to Mr. Theobald performing his duties as president of the union, that would be something that the union would be responsible for. If Matt were to go to a football game as an invitee and slips and falls, that I think I could understand where the union would say we're not on the hook for something like that. That's your issue. But if you're serving as the union's president, that's where I think our position would be. You have to step in and cover that.
I'm trying to remember like board meetings where, well, what if he's driving from school to school and he gets in a car accident? When he's performing presidential duties, he's bringing all his wonderful cookies and everything that he was delivering this year for signatures on stuff. You get a cookie, right, Matt? Anyway, so that's kind of the commentary I've heard from board members was just, just that. So I think that's what I recall the indemnification was to, like, and same thing with the workers' comp, which could be dicey, but we just have to see it have to be reimbursable because we're running it through the payroll.
Yeah, like I completely understand that explanation. It's just the concern with non in the first sentence is any and all claims demand suits or other forms of liability. So that's the whole gambit of any scenario. So if there's an accusation of Matt defaming somebody in the role of his presidency, right? Would that fall under this expectation as well? You think that having any and all claims, like I could completely understand trimming it down to workers' compensation, but we deal with a lot of stuff outside of just the representation portion of it. So I think that the any and all parts is very, very concerning because of how broad it tends the interpretation of this language. I think that the second paragraph addresses the board's concerns outside of that lengthy first paragraph.
Does that, Gary, on that first sentence though, on number 9, does it address at all your concerns? If you keep reading that where it says that may arise out of granting this full-time temporary duty assignment. Like, I mean, and I think that's what we were trying to get at there is if it's a loss that comes out of working as the union president, why would the board be on the hook for that or have to front the defense of something if he's doing it or alleged, I guess, to have done something while serving as MCEA's president?
Right. I'm trying to think of a scenario in which they would be on the hook for that. Like, so if he has a duty of fair representation allegation against him for one of our members who said, I had a meeting with the district, you didn't show up, et cetera, how is the board on the hook for that? I don't understand how they would even be bought into that situation. That's marrying union business and district business. in my opinion. So that's the part that I have a concern. I can't think of a scenario in which the board would be on the hook for anything MCEA related, as far as him conducting business in the MCEA capacity.
You want to email it to me?
I'll give you one example that I could think of off the top of my head. Let's say, go back to the hypothetical Julie brought up. If Matt is driving to a school site to represent a member and is involved in a car accident, and because he was negligent, he changed lanes without a turn signal and causes a catastrophic injury, the suit is going to be against the Martin County School Board. It's not going to be against MCEA. And that's where we would say, no, he was acting as the president when that happened. And we would turn back to MCEA and say, this one's on you. That's, I think, an example. The defamation was a great one. But I just, why would the board, wouldn't MCEA agree in that scenario if that car accident occurred while serving as MCEA's president, that the board would be held harmless in that situation?
Well, I mean, I don't understand why the board would. I completely understand your explanation. I want to say that first and foremost. But if he's driving from work to the office and he gets into a fender bender, based upon your scenario, you think that the person who he runs into the back of, like, he's absentmindedly checking his text messages and he rearing somebody, right?
This guy's getting killed right now, and he hasn't done anything wrong.
My thing is, unless he's in a vehicle that's assigned by Martin County that has the Martin County School District logo and insignia on it, how would the person that he run into automatically says, I'm going to sue the school district? How would they even know that he's employed by the school district?
He is, but he's a teacher on special assignment, and he's our employee.
Yeah, I think it's a huge reach. I think it's a huge reach.
So can we take
Gary?
you
don't know plaintiff attorneys very well, then, because I'd rather sue Martin County
deep pockets. Find the deep pockets. Yeah. Find the deep pockets. No, I think so. Look, can we take a stab at this language, because I want to look at that a little bit to make sure that I'm not speaking out of turn, but I actually don't think that in that situation that we would really dispute that. I mean, I think we would argue from the point, in the car accident side that, like, sorry, Matt, but Matt's on his own, like, in that situation. He's not MCA or Martin County School Board. But I think the bigger concern is almost not that first sentence. It's almost the second, or maybe it's the third part, which says any claims brought against the board at any time by Theobald, which is super broad, because that doesn't cover what you just said. That covers, wrongful termination, like, I mean, anything that could happen against him, that covers if he's at the football game as a guest, that covers that covers anything. And I think that's the part that really we want to be concerned with. So what if we take a stab at rewriting this to get, assuming that my initial thought is correct, that we could get close to what you're saying, right? Because I think we can. I want to do a little research on it to make sure I'm not speaking out of turn, because it's not my area of the law, but I think that's right. And so what I wanted to make sure is that we guarantee that if he's on MCEA time, MCEA job, MCEA stuff, then yes, if an employer needs to be held liable for something, it's probably MCEA, right? Not the board. But if he's just at the book and he's wronged in some way by the board, we're not giving away his right as the union president to challenge that. We're not giving his right as a citizen to challenge that. We're not giving you guys a blank check to say, hey, good thing signing this, you're fired. You can't argue anything, right? Like, I don't think that's what your intent is, but but I want to make sure that is not what we're agreeing to.
I hear you.
Makes kind of sense.
It makes,
I think
all that made sense.
I think we can take a stab at rewriting 9 in a way that is agreeable to everyone and clear to everyone we're talking about.
Yep, I get it. MCEA just doesn't want to indemnify something beyond what they would normally indemnify something that their president would hold them responsible for, is what you're getting at. Understood. Yeah, if you want to try to tweak it up.
And I don't want Matt to indemnify someone personally in a capacity that he would otherwise not have to do, right?
Yep.
Like that he wouldn't do as a teacher, right? As a teacher, he wouldn't have to sign that, you know.
Gotcha.
Let me get back on track here. Subject to the 10, subject to all the contract CBA policies. I don't have any concerns with that. Teaching position, which he's qualified. I don't have any concerns with that. I think that's in the actual CBA language. What is a teacher on special assignment contract in 12?
So
He froze. Oh, you're back.
I don't know why I keep freezing.
Because you're so cold up there in Tennessee.
It is freezing in this basement. We actually talked about that too. Is what does that look like? How is that different than an annual contract? And I think Ms. Ressanini had one, if I understood, a teacher on special assignment contract. Julie, is that right?
Yeah, all employees get a contract at the beginning of the school year. So it would just say, instead of Spanish teacher at South Fork for Karen, it said teacher on assignment. But it's the same contract that any teacher would get.
So is that the same as his annual? It's just like the assignment that is on his annual contract, or is it a separate document? Just the assignment?
Well, the assignment comes out of our ERP system. So we basically grab our boilerplate contract, grab his name and his assignment, put it together, and then send it to him and ask him to sign it. All employees sign a form of their contract based on their union or administrator, bargaining, non-bargaining.
Okay, so if I look at 10 above and it says he shall remain subject to the terms of his annual contract, is that the same contract that we're talking about?
Yes, I mean, I'm happy to send you a blank one that we used last year if you'd like to look at it. What we didn't want to do was create something here that then violated the contract that we're going to hand him and ask him to sign at the start of the school year. And then he has this separate MOU. That's what we were. But the other one is like a couple paragraphs of a one pager that just, I think there's salaries on there as well.
So it's just the annual, it's the teacher annual contract with a different position on it. Is that what it looks like? Because we could always attach it and just say that, upon the approval of this document, Theopold will contemporaneously execute a copy of the attached Appendix A contract. Then there's no, what does it say, concerns.
Yeah, that might make sense. And does that make sense to Matt, what you understand, or Gary? It's just it's not a different contract that they're going to create specifically for you, but it's just a contract that I think it's like your normal contract. It just says teacher on assignment.
Yeah. So as long as that's all it is, it's just a designation. I don't have a problem with that.
Yeah. It's the one that we all approve annually, Matt and Skyward, that's sent.
Okay.
That's what we're referring to, and it's easily attached, but
I mean, does that have any, how do I word this? I mean, outside of that document being a designation, is there any, is that an actual binding contract, or is that just a document that says you're an employee, you get paid this amount, et cetera, et cetera? What exactly is that contract?
it is provided to all employees that we're required to do, to send you because we're annual contract employees. So there is a paragraph in there that lets you know that there's nothing in there that says you get another contract next year. This is it, buddy.
I got you.
So when I read that,
sell it to people.
No, I don't. I try not to.
Yeah.
No, that's a terrible selling point, Martin. Okay, then contracts. All right. Missing. No, that's not the right one.
It's fine I think it's fine if it's what we all are saying it is. I think we just want to see it before and maybe attaching it as an exhibit is the best.
And actually,
I think it sounds like we're talking about the same thing.
Yeah, I mean, it's instructional annual sample is probably what I'm going to send them all to Terry right now.
Yep.
And my initial friend, Jeff Slanker, because Julie says Jeff Slanker, send. Okay, it's called Instructional Annual Sample. And then if you are a PSC, you get a different one. If you're a CC, you get a different one. And then there's a 1-year probation sample.
Okay.
So for
yeah, then it's what
instructional
we're
staff.
thinking.
Yeah. So I
Okay.
just sent them the ones that Mitchell had already approved from last year that we sent out.
Yeah, that's just his normal contract, it sounds like. So yeah, we don't have any problem with
Yes.
that. Just wanted to know what it was, if it was different from.
And actually,
Okay.
if I can interrupt for a second, I apologize, and kind of go back to 10 and how it might relate to number 9. You know, the subject to terms of his annual contract, the collective bargaining agreement, the policies of the board, et cetera. You know, I'm imagining a scenario where I'm not in a classroom. I'm working here at the office, and I post on social media, you know, about a negotiations, you know, an announcement for a negotiation session, and it, you know, on there it has a timestamp of something that would be normally during the school day. You know, we have folks who like to look at the union with a fine-tooth comb. And, you know, if I was in the classroom posting while I had kids in the room, that would probably be a violation of board policy. Somebody could call me out on that, and there could be, you know, consequences. You know, how does that work for number 10? I mean, obviously some of those things wouldn't directly apply.
I think that you're working in the capacity of your role as a president. So if you're posting something on social media or you're giving an update on negotiations, how is that not a function of your role as the president?
Well,
So
and,
like, I think that we stay clear away from these outside hopeful attorneys or whatnot that could
wannabes.
Yeah. I just think that it's hard to differentiate. The only thing is that we're establishing is that you're a teacher on assignment, right? But your full-time job is acting in the capacity of the president of the organization. So there's not a school board policy that could be applied to say you can only act in your presidential capacity during these hours when you're on full-time leave. Okay. So just imagine you're not on full-time leave if you're still held to not perform your duties during the course of the academic workday, right?
Understood. And so I agree with you, Gary, on that. And Terry, I saw you nodding your head too. So
yeah, I think so.
Yeah.
I think Matt, that the
That makes
intent
sense.
there is, even though you're on leave and you're on special assignment, there are certain obligations when you're a teacher and you work with a school that would apply, like don't communicate on social media with children. Like there are certain things that that's what I think that's aimed at, not
exactly.
Yeah, not the stuff Gary talked about.
Well, and so in that light, and I appreciate the clarification. In that light, if somebody were to bring an ethics complaint against me for posting on social media during the school day, as frivolous as that might be, in terms of indemnification and my ability to respond to that, does it feels like 9 as written here would sort of limit my ability to you know, take appropriate action as is. I know we already addressed 9. I know we're going to rework it, but I'm just, that thought popped into my head as that question kind of came up. And I just want to make sure that yeah, I don't want to sorry, I'm drawing a blank. You know, I don't want the board to be on the hook in the car accident scenario any more than I want to get in a car accident, you know? But I just want to make sure that if there's somebody, or if that I have the ability to defend myself or protect myself if I'm acting in that capacity.
Okay, so that, Martin, I think that might be better a question for you to answer than me. But if I hear what Matt you're saying is, if you were in a, you would not want to be restricted or prohibited if you were in a scenario where you felt you were wronged in some way, that you would not be able to have some way to pursue whatever it is you felt you needed to pursue. I think I can answer it in the general sense that the indemnification, again, our intent there is if there is a claim for loss related to things that you are alleged to have done within your capacity as the MCEA president, the board would not want to be on the hook for that. If hypothetically, I mean, when you say ethics too, you're talking PPS ethics, professional practices services. I guess I'm not sure what the question is, but I hear the concern. I don't know what.
You're summarizing it fairly well. I think you're doing.
I'm just trying to figure out where you're going, but I get what you're saying, but I don't know what I can say in response to that would answer any questions.
Understood.
I think I think a couple of things I'll respond to as I can. I don't know. I think that your obligation to remain subject to the terms of the CBA and the annual contract and the principles of professional conduct kind of come along with you being an employee of the board and holding an educator certificate. I think the argument then is your actions as a board, your actions as the president are not they are outside of that, in violation of your ethics. I mean, can someone bring a complaint to the DOE? Anyone can. Anyone can at any time. They have the right to do that, and we have to defend that. That's not something that the board can control. Ideally, the board isn't doing that for union activity, but anyone can bring that, and we have to defend that. And I think ultimately we can defend that, right? Because your actions as a union president are protected in capacity, although you still have some restrictions, right? You can't, there's a lot of code of ethics that are like you can't do no matter what your job is. But I think as we try to rework and come to an agreement on 9, I think your concern will be assuaged, because I think that you will continue to maintain, no matter what this contract between you and or this MOU between MCEA and the board says, you maintain your own personal rights to challenge things that you want to challenge people that you feel need to be challenged. And I think the only concern is if the board is that person that needs to be challenged, we want to make sure that you still have the ability to do that. If they take some action adverse to you that is legally actionable, you should still have that ability, even if you're in the teacher on special assignment. And I think we can get at that without undermining the concept that Terry's talking about, which is the board, on the same token, should not be liable for things that you do when you're operating as MCEA president, right? Everyone should be in their proper role. I'm not saying that artfully, but I do think that it's a concern that I understand it. We may not be able to, legislate exactly some language that will solve it, but I do think that we can get pretty close to an acknowledgement that you're not going to be somehow trapped by this language so that you can't act if you feel like the action is needed, or subject to some rules that you don't feel like you should be subject to because of this language. I think we can get there. I think we're already very close to that. Sure. I don't think that's the intent.
Yep. No, I appreciate that. And not only thank you for the clarification, but thank you both for getting in there and reading my mind. You guys did a great job collectively on that. I appreciate it.
All right, Mark. So where were we? We were on the contract, right? Number 12 is where we.
Yeah.
Yes.
Yeah, and I think we kind of are at a good place with that. Because if we see it whether it's attached or not, if we just see what you're talking about and it's that annual contract, which we think it is, I think we're going to be, that's fine. The 13, the only thing I am concerned about here, I think, is that separate and apart from this agreement, we're going to have to resolve the opinion and award, right? And I don't want to agree to this and then that somehow undermines our resolution of that award. I don't think that's your intention with this language. Maybe it is, but does that make sense? I don't want to say like we agreed that this supersedes the opinion and award, and then we come back and say, all right, so how do we recapture his FRS? And you say, no, we don't have to do that. You agreed that this is superseded, right? I don't think that's what you're saying, but
that the intent was, I think, well, I don't want to blend too much bargaining versus resolution. I think what our intention was is more on a looking forward basis, that for purposes of the upcoming school year, we want what governs the relationship to be what's in this MOU, not what somebody said in the past.
yeah.
So
I think that makes sense.
That was the intent, not to lock you into a position now and then go and, you know, argue something in the arbitration matter, which I think is again, as we discussed before at the beginning, our desire is that we can mutually work to resolve that. So that was not, if you need to add some qualifiers there that you would make you more comfortable, I'm happy to do that, but that was not the intent.
Okay. Okay. So yeah, that was just a concern. Let's see. Okay. I mean, it's similar with the past practice or the CBA. I mean, I think that we all acknowledge that like the language of this MOU covers this year. And that's the term of the MOU. That's what we're trying to do. I think there's some concern that we're limited. Like, I guess I'm not sure what you're trying to say by create a past practice or create a precedent. Because I mean, in what capacity? Like, you don't want us to use this in some future arbitration? Like, I guess what, can you explain that a little bit, what you're trying to get at there? Just so we understand a little bit.
Yeah, and it kind of goes to what I said at the introduction, was our view was with working on the MOU, we were looking on addressing how we're going to handle things 24-25, recognizing that the overall unpaid leave provisions is something that might need to be addressed outside of the context of an MOU. Just like when we left off last year in the last bargaining session, there were a lot of back and forth about the terms of unpaid leave. And so what we were just trying to do is just to make it clear that, which I think is kind of what the purpose of an MOU is anyway, is really that we're locked in. We're trying to focus this on this year, and it's not going to impact what we still need to bargain for 24-25, because we don't have a collective bargaining agreement yet for 24-25. This MOU is kind of jumping in front of all of that. So we just wanted to make it clear that this MOU is for this, but any other bargaining related to the 24-25 contract, you know, the MOU is what it is, and it is in place. And if the board approved it, it would be in place, but we didn't want that to otherwise limit the ability to discuss unpaid leave or any other forms of leave during our collective bargaining sessions.
Okay. No, I think that's probably right. I just think there's a little bit of a concern about what, like you said, that's kind of the purpose of the MOU. So what did this add was a little bit of our concern. And I think there's also just kind of a practical one, which is our hope is that we work this to the point that it works, right? And so we're fixing it, we're making changes to it, we're doing it. We're not trying to use it as a hammer, but as a tool to actually facilitate this as part of the bargaining, right? To say, listen, here's how we've done it, and this is a good tool, and it's worked for Matt, or it's worked for Karen, or whatever. If it hasn't, here's what hasn't worked. So okay, well let's talk about that. Gary, do you have any other thoughts about that response?
Yeah, I just think it's redundant. I think number 3 clearly establishes that the MOU sunsets after June 30th, 2025. It shall automatically sunset and have no further force and effect after June 30th, 2025. So why do we need that last caveat if number 3 expressly puts a limitation on when this language will be followed, right? It specifically says it sets at June 30th, 2025. And I don't see how this would affect our ability to open up the article in which unpaid leave falls in the collective bargaining agreement, because this is a separate document. So
And
that's my understanding of it. I just think that it's redundant, and it just puts like this language. It just seems like we're not trustworthy. Like we're going to use this as something to put on the table and say, oh well, we have this, so you have to do. That's not how we get down, Terry. I don't think that the board has a concern. We should have a concern over us using it as a past practice, because that would only be with respect to a grievance and arbitration that you could use a past practice argument. So I just don't understand the need for 15.
Okay. Gotcha.
Yeah, and then this has to be voted on by the board, right? And I think that's something we've talked about kind of throughout this whole process. What concern from the beginning of Karen, so we acknowledge that. So there's some things that we need to work on. Get back to what's the procedure that you recommend to do that?
Yeah. So the board meeting. There's a board meeting on the 16th. And so our hope was that we would be able to have this on the board agenda for the 16th. Because I don't think the next board meeting is till 3rd Tuesday in August.
August 20th.
Yes, which would be after the start of the school year. I don't know from a timing, like if we were to try to get back together, how that would work for that, Julie. Like I know.
I mean, there's two
from
trim meetings and there's a workshop, and sometimes if it pleases the board, they close the workshop like they did last night and they look at 1 or 2 things to have a special board meeting.
Okay. I mean,
I can't tell you that's going to happen, but there is past precedent that like on the 9th, I might be able to get them, or the superintendent may request the board chair to close the workshop and then advertise, they advertise a special meeting, and we could maybe do it on the 9th, but that again, still, well, school starts the 12th.
well,
But I have to, if there's any palatability for an opportunity for partial release, I have to figure out where I'm putting Matt for teaching.
What's the requirement, the notice requirement, remind me, for the agenda? So for the meetings on the 16th, I assume they have to post the agenda 48 hours or something in advance?
a week, 7 days in advance, we would put, or there could be good cause to add a late item. So
Yeah, I mean, we have to have it by the 6th, but agenda post date is the 13th for the 20th. Or are you looking for the 9th?
we're looking for, I think he's looking for the 16th of July.
Yeah, I was just seeing if we even had time to do it, if it was even possible. I didn't know if there was any
Yesterday was, it posted yesterday.
But we could, I mean, you can do a late ad for good cause. The chair would have
Yeah.
agreed to that. But the closer you get to the board meeting, I just know if we say, here's an MOU, you have 24 hours to look at it, we might get, hey, no, but understanding too, the timing of it, we've got separate from this, where we've got the arbitration matter is required to be addressed next week. Our hope was that we'd kind of flush everything into one board meeting, all of it at one time. That was our plan. I think we've got a couple things to work through. So I just don't know, Julie. Even if we met again another day, the 11th, the 12th, or the 15th, I don't know how the board, I just don't know if that's feasible timing wise versus if we were to do it August 9th. But if we did a part-time situation, again, just hypothetically, I do think you would need some time built in to have those discussions as to whether that was something that would be entertained. Just stinks there's no board meetings between the 16th and the 9th.
Well, there's trim meetings. There's
But would they
I
attach something like this to that?
I don't really have I don't think so, but I don't know if you have any experience with that. I don't really remember. I
No,
mean, trim meetings
never
only
done it.
happen. Trim meetings
Yeah.
only happen a couple times a year for budget, and it's usually the CFO, and that's his, they're scheduled meetings according to statute for him to do what what the board needs to approve for a budget. So I don't know if they would close those and do another one. I can certainly ask if the superintendent's admin who manages a lot of that to see if there's a possibility. But I know we've done it at workshop because we just did it last night, but the other, I'm not really sure, fortunately.
So when would you all be available to maybe make some red lines, get back on something like this and talk through some of these issues? I can tell you though, for your scheduling wise, for purposes of the part-time question, that's probably something we won't be able to have the conversation on our side until the 15th. So if that's something that you wanted to kind of look at for purposes of the MOU, I don't think before the board meeting on the 16th that we'll be able to give you the position on that. If that was something that you really wanted to look into, I know that you said that was to maybe help address some of the concerns from our end, but also if that's something you're interested in, I think we'd have to have that chat. If it wasn't, and we were just going based on the template that we've got now with some of the revisions outside of the part-time, I mean, we'd have to get together. Julie, I just don't know, Julie, how the board would, if we got them something on the 12th, how that would go.
The 12th of August?
July. Like if this Friday we've had a TA on an MOU and said a late added item to the board agenda for the 16th, whether or not that would be sufficient time.
I
just don't know. I don't think we know that here. So we can try to find out, and that might affect scheduling, but.
Well, do we try to schedule another one of these on the 12th and get red lines to you tomorrow for your, that's okay, right? We can submit red lines to you guys. Do we try that, or do we, what's your availability for something like that? I think we can probably on our end, we could probably, we just prioritize it and we'll figure out a way to get it done, right? But if it's a fruitful action, then we'll take more time and make sure we get it done correctly. But I think we can. None of this is too major, I don't think, with the exception of the part-time, full-time issue, which, like you said, has to happen, is not going to happen anyways. So maybe I think that conversation is worth having, I guess, is my position. We probably need another conversation with Matt and MCEA, but based on our initial conversation, I think that part-time conversation is at least worth exploring, because I think it might solve some issues. But I can defer to Gary and Matt on how important that is to them, and that already pushes us to a
August.
point where we can't do it.
And I think on that, we would need probably, Julie, I think on Monday, we wouldn't have a good indication of really what direction we would want to go with you until, it would even be Tuesday, because we would have to have a meeting on Monday, float the idea, talk through it, and then have some direction to be able to come back and talk to you about. So there'd be, that would be something you'd want to kick down anyway to a later date.
Well, and we can get you probably some idea of what that looks like in an agreement like this, or at least our idea of both, right? I mean, I don't know. I'm maybe creating work that we don't need to do. I'm kind of open. I'm not sure the best way to handle this. So I'm kind of looking for guidance from everyone here, but we can
Yeah,
give you
no,
red lines on both directions on, you know, just red line this, and we can give you like, here's what I think it looks like if the board has an appetite for part-time. I don't know if that helps us. I mean, it just seems like we're in a bind on the July 17th, which of course, I don't know. Is there an
Yeah.
appetite for splitting this? Is there an appetite for doing the resolving the arbitration component and then at the 17th if we can, and then still working on this for a workshop or whatever we can get in front of them? Or do we want to put them both in a position where they're working simultaneously? And I don't know that there's an opinion either way. I don't know the thoughts on that.
We probably need to talk about whether there's a possibility of splitting it up. I mean, as we mentioned to you, Martin, when Jeff and I called you out, like, I think there's an intent here to move quick and get it all through. Yeah, I think that was and still is. I think we're just burdened a little bit by the timing of it. So maybe my thought would be let us talk offline and see timing wise how things would work out if we were to get something in the next couple of days. If that was not plausible, then it may just seeing about whether these trim meetings that are publicly noticed, if there's a way to tack onto that and just kind of see what the options are here to try to get this thing going. And frankly, I know you got the school year starting. And so if this was a scenario where there would be a split time, you know, we got to make assignments. And so we kind of got to move quickly on our end too. So I think maybe that's the answer.
Yeah. So then can you and I or Jeff and I or someone get on the phone like tomorrow to figure out where we stand on some of these things like tomorrow? And in the meantime, on our end, we'll do some of the redlining so we have it in our back pocket and ready to go. And that way I can also kind of, we can let each other know like tomorrow morning, perhaps, like where we stand on all these issues and here's the best possible outcome.
Terry, I just have a recommendation. Maybe they could come up with 2 red line versions, one with part-time release and one where you review our full-time release.
Yeah.
And so we have both in our pocket. But both of those things in our pocket, and then you all will, outside the negotiating process, determine the arbitration award and with Jeff, as some work he's already done, and that would be done outside the bargaining table, because that's not something we're bargaining. That's an award that we're working through. Make sense?
Yeah, I mean, if we had 2 versions of it, we could talk through that on our end. Just, the TA, normally I'd love to sit down and TA on something with you, but if you've got a concept, it'd be nice to see what those look like, and maybe we could get some more feedback for the next time we get together.
That sounds good. We'll do that. And I suspect we'll have to come back together as a group anyways to do that. And the question is just how soon do we need to get back in? So I got a couple deadlines, but I can get you guys that tomorrow too, I think.
Do you want to look at any time that you'd like to try to get back together and just get it scheduled? At least a date? What did I say? Today's the 10th. So, the board meeting is the 16th. We could try, it would be nice if we had it on the 15th. Terry?
If we had our meeting together on the 15th?
Well, yeah, I definitely want option A and option B from them, full release and part-time release in a response format similar to the MOU, redlined, and then
right. Oh yeah.
And then a meeting, if of the minds happen regarding arbitration, which is outside of this, and then we may have something to go with executive session.
Yeah, if we could, maybe we could. I'm looking right now. I should have some time on Monday. I'm looking right now.
And then we would need, we typically have a meeting prior to executive session the way we do, so that we've, those that'll be in session understand what we're presenting.
If it was before 2:00 p.m. on Monday, I would be available.
Okay. I mean, if you receive the items prior to that and just want to bring it to our meeting, you've already, but that's the thing. We probably have
Got
to.
to exchange it at the table. Yep.
Yes, sorry.
Yep. So it could be also just a quick meeting on Monday for the purposes of being able to pass things across the table.
That you've worked on.
That might work. Would that give you time, Martin, on your guys' end?
So we present to you the 2 red line versions Monday.
Yeah, and then we would potentially have some feedback. When then we'd have to have another follow-up session really to present the feedback to you because of this. Obviously, we've got to do everything in the sun.
Yeah. So do we need to? I mean, and we're
I think
jamming it
we
in here
can
to try to
answer
get it
that.
done, right? Do we need to meet?
Sorry, Martin, go ahead.
Do we need to give you red line versions Friday, like 2 days from now? Do we need to
I
meet
think
Friday
anytime
in that?
Monday to me. I think if it's
It's all the
Monday,
same.
yeah, because we're going to be meeting Monday evening to
Oh,
go
okay.
to talk through some of it. I can present. I understand the concept without the red line for what it's worth.
And I can get you the red line by Monday. That's not a problem.
Then yeah, anytime
do
Monday
that.
before 5 p.m. would be helpful. But I think we need to have that exchanged across the table during a bargaining session versus you just
Right,
emailing it to us.
I mean, ultimately, it forecloses. I mean, the timing just forecloses the ability to get this before the board on Tuesday. I mean, there's just no way because it requires us to get it to you, for you to have a conversation Monday night with the board, for you to bring it back to the table, and then for us to TA. And that's not. I mean, that's just not going to happen.
For the part-time release, it probably wouldn't happen. Yeah, if it was not part-time release and it was just taking the other stuff that we talked through,
Maybe
I think there's a possibility we could do it. Right.
Okay. Well, let's get something on the books for Monday. Let me have a conversation offline with my folks, and then
We'll talk.
And then we'll talk. Yeah.
Okay.
So Monday, Matt, Gary, Jeff.
Yeah,
Do you have any time
Monday,
constraints? I can pretty much.
July 15th, you want to try to do just at noon? You said before 2, Terry?
Yep. But anytime before 2.
I'm open anytime. I'm also open within that range. So if you guys, so I'm 2 noon is fine. 11 is fine.
Okay.
10 is fine. Whatever.
Yep.
I'm gonna
my
put it-
Monday, my Monday's good too. So whatever works best for you guys.
I put
Okay.
noon to 2 p.m. and then I'll get these notes on the website, and then we'll have them advertise the meeting at 2 p.m. and it would be via Teams
Yes.
Link. that
Yep.
will be posted on the district website. Okay. All right, do we have a plan?
We do.
Right.
We have a plan. Yeah, we have a plan. Terry, can you send that document to me, like email? I can't save it.
Oh,
way to edit it.
the Word document that I.
Yeah, the MOU. It's like won't let me save it, or maybe I don't know how to use it. I don't know.
I
Yeah.
did a
Both
draft.
ends.
I did one with a draft watermark on it. You may want that on there, Terry. I don't know.
I'll just send it to
Maybe
you.
there's a-
You're talking about the MOU?
Yeah, maybe there's a way I can pull it off, but it's not letting me pull it off.
I just send it to you. So
All
you'll
right,
have it
thank
in
you.
Word.
Yeah, it's better that it goes from attorney to attorney in my mind.
Yeah. Same thing. We exchange it across the table, so it's fine. It's just
True.
the format. Okay.
Okay. All right. So we want to go off record then, and
Yes, hold please. Figure this out. All right, stop recording it.